We are recording, and action.
Great. So, Gideon, are you introducing yourself or shall I go first?
I can start. I probably need no introduction with this crowd, but for the record and for all the people who are going to be seeing this online who aren't necessarily OPD contractors, I'm Gideon Newmark, Appellate Program Manager for the Washington State Office of Public Defense. My claim to fame is having been a law clerk for about 3 years and then coming straight to OPD, where I have been managing the appellate program, organizing CLEs ever since for about the past, is it 5 years or 6 years? Who knows? The time goes fast.
I'm Jean Marie Claver, Professional Responsibility Counsel at the Bar Association. Time does go fast. I've been here at the Bar Association for 9 years in my role as education outreach and all things that have to do with professional responsibility, including professionalism and civility. Prior to coming to the Bar Association, I spent 20 years in private practice. I practiced in a tri-county area, King, Snohomish, and Pierce County. I was primarily in state courts full disclaimer, did not do appellate work, but did a lot of just work in state court. I did quite a bit of work in contested guardianships, straight out guardianships, elder law, trust estates, etc., and everything that both on sort of the client to attorney level as well as to hearings and trials, and not very many of them, quite admittedly, in the Superior Court level, but did that for 20 years. And then came in-house, so to speak, to work in full-time in professional responsibility. So what I hope to be bringing to this webinar is just kind of a really, I hope, a deep knowledge of the rules of professional conduct in the comments. And it is really my belief that as we go through our practice days and we're actually doing the work and representing our clients, representing entities, etc., that the rules of professional conduct really should be sort of the underscore, or if you will, the operating program under everything that we do. So like you, and like many of you, I didn't graduate from law school last week. And in fact, when I was in law school, I've been a lawyer almost 30 years, the rules of professional conduct were not even called the RPCs. And so what we do here, what we'll be doing here is applying the rules of professional conduct to hypotheticals, but I will be spending some time kind of pounding on the rules, what they look like now, what's a good way to interpret them. Again, if only to help you sort of issue spot that when you have particular issues, not that we'll have a whole memorization piece of it, like we all, had to make sure we had a lot in our heads for the bar exam, but really, do I understand that there's a problem here? And when there is a problem, do I recognize it, and do I know enough to look at the rules of professional conduct and perhaps look at some resources? Part of what I also do at the Bar Association, in addition to sort of the outreach piece of continuing legal education, is I do staff our ethics line. The ethics line is essentially a confidential source for all licensed attorneys, and that's anywhere in the world, Washington licensed attorneys and legal professionals, to speak to someone, a consultant, not their attorney, and not an official spokesperson for the Bar Association, but to essentially discuss their decision and their analysis for a prospective ethical issue that they're running into. The ethics line is not something where an attorney kind of says, I did this last week or last month. Do you think this is right? Or what do you think I should do about, what could I have done about that? But it really is sort of future decisions. So I encourage attorneys to use the ethics line. It is confidential. It is done on a phone basis very intentionally because APR 19 does speak of the confidentiality factor, and we're a public records agency, so we do not want, I prefer not to get emails, don't want emails, and I will never respond with emails. And I do get calls from criminal defense attorneys quite a bit from all over the state. So I do know that at least the number of the line is out there, and hopefully folks will think of calling. And if not, the ethics line. If you prefer not to call the ethics line, RPC 1.6, which is confidentiality, does speak to a very limited exclusion where if you are sort of exploring the professional responsibility consequences of what you're doing, it's not that you're allowed to discuss all the factors of a case, but there is sort of a limited allowance of you to go to resources, and that may be your colleagues, to discuss what are the ethical implications as well. And as we go through today's hypotheticals, you'll note I'll probably hit on 1.6 more than once, that is sort of a highly protected part of the rules of professional conduct, and so anytime we kind of go outside of it, it's sort of a, or carve out any exclusions to it, it's kind of a really big deal. So I'm happy to be here. Again, I apologize for those of you that were waiting on the Zoom platform. I do apologize for the extra few minutes that you had to until we finally got a microphone that worked. So carry on, get in.
Yes, thank you. Thank you, and thank you so much for being here, Jean Marie.
Absolutely.
Great opportunity to get some ethics credits for appellate law, which is, I think, not too common. And you are, of course, the expert. So we've got all these hypotheticals, which hopefully you've had a chance to review already, speaking to those in the audience. Now, these aren't all intended to be super head scratchers. Some of them might have pretty obvious answers, although I'm sure we'll stumble upon some wrinkles that I didn't anticipate when drafting these. I also want to emphasize, we're not necessarily, I think some of these hypotheticals include both ethical questions and tactical questions. Sometimes I might be asking, would it be unethical to do X, when it would actually be really stupid as a matter of tactics to do X, which is less what we want to focus on. However, as Jean Marie pointed out to me when we were going through these, sometimes it would be so stupid to do X that it would violate your duty of competence. So that is still relevant. Really, you know, tactics are at least tangentially relevant to pretty much every hypothetical because you do have an ethical duty of competence. But because that's all pervasive, I think we want to shy, and we have got a lot of hypotheticals, not a lot of time. I think we want to shy away from getting deep into, we want to talk about, can you do this, more than we talk about, should you do this? Because I think everybody's got a solid grasp on tactics, and that's not really the topic here. So I think we can dive right in. Here's one that I've experienced, probably everyone's experienced, and you probably already have thought about this, but good starting place. What happens if your client threatens you? Your client's not incarcerated and threatens you with physical harm. Can you withdraw from the representation? What can you disclose to the Court of Appeals in your motion to withdraw? And is there a difference if the client is incarcerated versus if they're in the community?
All right, so I'm going to sort of pounce on the rules of professional conduct, which I think are sort of the primary rules that a lawyer would be thinking about as they're working through their analysis of how to respond to this. And for those of you that may read the RPCs extensively, and I'm hoping that there may be other RPCs which I don't mention because so many of them, they all really interface and intertwine with each other. Let's talk about the physical harm aspect. You've been threatened with physical harm. That clearly is going to reflect adversely on your client. And that does go to RPC 1.6, which is all about confidentiality of information. So in particular, RPC, and we don't actually have all of the RPCs linked here, so we'll start with 1.6. So RPC 1.6 is all about confidentiality and everything relating to the representation, but for the fact that you had this client, you would not be disclosing that. So if that information if disclosed would be adverse to the client, in fact, it needs to be even more protected. There There are some extremely limited exclusions to giving information out under 1.6. There is a mandatory required. There's only one, and that's to reveal information relating to the representation of a client to prevent reasonably certain death or substantial bodily harm. And the rest are permissive. But the concern is the physical harm aspect. And so part of your decision under the other rules of professional conduct will be to what extent is that client in fact capable, and what is sort of the context of the physical harm threats. And I can say this because I've talked to attorneys who have clients that essentially kind of wind into threats all the time because they have mental health issues, and there is no real substance, at least the attorney believes that there's not, to those kinds of threats. We don't have a crystal ball, and there may be those clients that in fact have a history or a track record of severe or extreme violence, etc. So the discussion of what can be disclosed to the Court of Appeals in a motion to withdraw, and motions to withdraw are primarily under RPC 1.16, which is the termination or withdrawal of representation, is extremely limited because of that whole 1.6 piece. The other part of this analysis, and I want to give you all a chance to jump in here too, is let's say you decide to keep that confidential in your attorney-client relationship, and let's say you're either going to stay in that representation and not utilize 1.16, or you're going to withdraw and read through 1.16. Are those threats creating any kind of a conflict in that representation with you such that it's a material limitation based on those threats to you, which then becomes a material limitation under RPC 1.7. So that's kind of the RPCs sort of primarily with what to do with that information. As you can tell, so many of these answers are going to be facts and circumstances dependent. Is there a difference if your client is incarcerated? I would opine that that has to do maybe with the severity and the ability to carry out any kinds of physical threats. And then the last thing I want to do, and I do know this is in our materials, Gideon, is there is an advisory opinion. It's 201701, lawyer withdrawal, disclosure of confidential client information in a motion to withdraw. And I'll just give you the nutshell of that, or sort of the high level points, is that that advisory opinion does speak to a decision to withdraw when there is not an imminent risk of death or serious bodily injury. So let's say that threat is one in which you don't believe the client will or would carry out. This advisory opinion, I think, does a very good job of going very deeply into what should you not be disclosing to the court, and how to kind of work with that in your motion to withdraw.
Okay, so
something to think about.
Yeah, it sounds like the incarceration almost certainly makes a difference, because if they can't get to you, what's your basis for withdrawing on that? But it's always, would you agree that to some extent, personal conflicts are personal? What one attorney shrugs off is going to be materially limiting for another attorney who doesn't have the ability to shrug it off.
Well, yes, but I think the most important factor in this is not how, to a certain extent, how it affects you personally, but actually how authentic is that threat from what the attorney knows about that client. And that also goes into issues of mental health issues, and clients who may be acting out and throwing that into their communication. it's not something in which maybe there's a real intention or an ability to carry through. But yes, certainly 1.7A2 is all about, is there a conflict with actually the attorney's own interests insofar as what they want to do, which should not be applied lightly. I mean, one has to sort of be careful about considering every, strange look from a client as something which is threatening to the attorney. Maybe the attorney actually has to learn a little bit more about client management as well, and that piece of the attorney-client relationship. And I do get sometimes those calls from attorneys who are fairly new to the practice, who are learning how to manage sort of the communication piece of it and sort of understanding how to create the boundaries and the appropriate communication levels with the client.
Do any of our participants have any questions or comments on this one, or should we go ahead and move on? Don't want to get bogged down because we've got a lot.
We're never getting bogged down if we're talking about RPCs. I just want to throw that out there.
Yeah, I think there's more, like all of these, there's probably more depths to plumb, and you can get really deep into these. They're kind of fractal, and you could think about different different factual scenarios, but in the interest of time, let's move on to hypothetical 2. You receive several highly delusional letters from your client indicating that the President of the United States is involved in a conspiracy to kill him, and that the appellate process is a sham to distract him from his imminent assassination. It is questionable whether the client understands the proceedings, and he clearly is not competent to assist you with the appeal. What is your ethical obligation? I think this is an interesting one because there is much written about trial counsel's ethical obligation for an incompetent client, but I think there's been a lot less written about appellate counsel's obligation.
Right, and that, to distinguish the difference between those, I think, Gideon, I think you will be the better sort of communicator on that level. I will talk a little bit about RPC 1.14 and RPC 1.6. 1.14, I'm not sure if that's actually on our list of RPCs, but I will kind of go into what that is, and it's not. Okay, so this is all sort of like, this is all giving you sort of the interesting and, oh my gosh, as soon as we're done with this webcast, I'm going to go look at these RPCs that weren't on the list. Love to hear that. So RPC 1.14 is representing a client with a diminished capacity, and so 1.14 is very clear in A, saying that the attorney, and again, this is Jean Marie kind of, I'm paraphrasing this. I encourage you to read the actual rule itself, make your own decision in the comments. But even if a client has diminished capacity, obviously the highly delusional letters is a trigger that there must be some capacity issues going on. The attorney has to take that client and create the most normal attorney-client relationship that they can. That is the preface and the premise of RPC 1.14. And even if the client is saying the appellate process is a sham, the attorney needs to kind of plow, I would suggest the attorney would need to plow forward and try to at least create as best they can to actually try to attempt some communication with the client. If the attorney believes that the client cannot understand the proceedings and is clearly not competent to assist with the appeal, can that attorney get any small kernel of information or direction from the client? And I think if the question is, what is your ethical obligation, the attorney is ethically obliged to actually sort of independently make that inquiry of the client themselves. And pulling in, so that was 1.14. 1.6 is confidential, so that inquiry and that information that attorney has is confidential. And Also, 1.16 is whether or not the attorney believes the attorney can continue on in that representation if there is clearly a complete breakdown. Another RPC that is not that is not actually in the linked list, but is pretty, I would say, kind of also provides a context, is RPC 1.2, which is the scope of representation. And comment to RPC 1.2 really speaks, I think, very clearly about the allocation of authority between client and lawyer, and also speaks to the fact that the lawyer should be making an inquiry into the client's understanding of what the role of the lawyer is and what the role of the client is, and see if they can make any kind of connection.
Great. And, you know, I say this one is sort of a trick question because I'm sure nobody was fooled by it, but I put the standard for competency at trial in this hypothetical. And of course, there isn't really a right to competency on appeal, as far as I know. So you don't get a new trial just because you're incompetent on appeal. And of course, the information of your client being incompetent because of that, as Jean Marie said, you probably can't even reveal that your client is incompetent on appeal.
I do want to say that particularly in the trial level, there are some advisory opinions that you can find at WSBA.org that do speak to if the attorney actually is required to bring up competency as some sort of a defense. It does go more deeply into 1.14, and that is seeking the client's understanding and perhaps permission, but also recognizing that the client is allowed to be the final decision maker as to what is disclosed to anyone outside of that relationship. And 1.14 speaks to actually a lawyer sort of communicating this, even if they think the client is at a substantial physical, financial, or other harm. But I just want to point out in 1.14, that is a permissive, that a lawyer is not required to jump in and rescue that client and to clear the air and to tell everyone the client's competency issues. It is, the lawyer will not be found in violation of 1.14 if the lawyer chooses to keep that confidential.
Yeah, and I've definitely seen trial situations where lawyers took it upon themselves to raise the client's competency. You know, the client's facing 2 years, and then they get locked up in Western State for 3 years because the lawyer went ahead and did that against the client's wishes. So I don't know if I've seen that come up as an appellate issue, but this is probably more, this topic is definitely interesting because it gives rise to a lot of appellate issues. Less relevant to our actual appellate attorneys, though, I think. Anyone else have comments? Don't have time to wait around for comments, so if you...
well, if somebody wants to, I don't know if there's capability of typing the comments, we can always circle back. Exactly,
right. If you're not fast enough, feel free to type it in the chat, and we'll come back to it, given time. Hypothetical 3, your client wants you to raise an issue with virtually no chance of success. The client's position is directly contrary to established precedent. Can you raise it? If you can raise it, must you? Just because the client wants you to raise it, do you have to? Does it matter whether or not including the issue would dilute the impact of other stronger issues in the brief? I could say this one comes up, I don't know, a lot. Comes up pretty frequently.
Regularly.
Yeah, regularly, for sure.
All right, so I'm really focused on RPC 3.1, and that's meritorious claims and contentions. The second part of that one paragraph rule is all about that a lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. And it looks, and so we actually have that, and then the 1, 2, and 3 are comments to Rule 3.1. And I would bring your attention to comment 3, the lawyer's obligations under this rule are subordinate to federal or state constitutional law that entitles a defendant in a criminal matter to the assistance of counsel in representing a claim or contention that otherwise would be prohibited by this rule. So it seems to me like looking at federal or state constitutional law is sort of the primary threshold. But in any event, the lawyer really should be and shall be presenting every piece of the argument that they can. Now, I know enough, and I'm sure everybody on this webcast knows enough about being a lawyer, that there are different ways of fashioning the way facts are sort of laid out for the court or issues being laid out to the court. So there's the 1.2 scope of representation, trying to explain to the client that you, the lawyer, are the strategy person. You are the one who is providing sort of the legal aspect of the representation. The client obviously presents the end game. That's under 1.2. But 1.1 is really the drafting aspect, and that is, so if you choose to go forward with that, and I'm not going to answer yes or no, but I am going to say, should you choose to go forward with that, looking at what's the best way, strategy-wise, to present a position which is contrary to established precedents and to which and hopefully you've communicated to the client is an absolute no-win situation.
Right. So essentially, you don't have to raise the issue, but even if you do, it's totally up to you how you raise it. You don't have to raise it in the way the client wants you to raise it if you can't ethically do that. I want to call attention to this part of RPC 3.1. I certainly built that into the hypothetical on purpose. It's directly contrary to established law. Now, I think there are different ranges of that. Your client wants to say, and this is a real thing that some clients do argue. I don't know if you've had a sovereign citizen client, but they say things like, there is no federal government. It's not real. It only has authority over admiralty law. You can't raise that, of course. But let's say they want to raise an argument that, the Supreme Court has already decided this issue. You're definitely going to lose if you raise it. Well, all you've got to do is make a good faith argument that, okay, sure, the Supreme Court decided this, but they decided it wrong. Here's why. As long as you're doing that in good faith, you're not being unethical. You have a separate question of tactics. Is that worth your time? And that's built into the hypothetical too, with the question of the question of does it matter whether or not the issue would dilute the impact of other stronger issues in the brief? I think it matters tactically. Probably right. Isn't an ethical consideration necessarily, but if or it might maybe it goes to competence. Let's say your client wants you to raise these 20 issues which are all going to lose. You've got 3 really solid issues which have a very good chance of winning. You might be running up against the duty of competence if you just do what the client says, write a terrible, incomprehensible brief that buries the good issues. But that's such a subtle shading, right? It's hard to decide that outside the facts of a specific case.
I also want to say that in the next sentence, the second sentence of 3.1, the idea or the word nevertheless, I think is pretty important. And so it really does carve out sort of a different position for criminal defense attorneys that civil attorneys can't even dream of in that respect. I think civil attorneys, it appears that civil attorneys can do more to carve out the kinds of frivolous claims by using 3.1 than criminal defense attorneys, which really, because of the risk of incarceration, the rule was drafted in such a way as to give those clients every bit of an opportunity for defense as possible.
So I have a question.
Yeah.
Can you hear me? Oh,
Yes.
Hi, this is Erin Sperger. I was also thinking about this in terms of the statement of additional grounds.
Mm-hmm.
So typically I just tell clients, if you're unhappy with what I've written, or you want to raise an issue you think I didn't raise, you can raise it yourself in the statement of additional grounds. But I'm wondering what you think about, like if you know it's something you can't raise or it is contrary to the law, can you tell the client that they can raise that for themselves? I mean, I know they always have a right to do whatever they want in the statement of additional grounds, but I'm just wondering how much we can say that ethically, to be like, oh, well, I can't raise it, but like you can raise it if you want.
My take would be there's no limitation on that other than perhaps, in terms of just raising arguments. Now, maybe if the argument the client wants to raise, this is out on a limb, but if the argument itself would be a crime or fraud, maybe that I'm not sure how that would work exactly. I'm sort of talking myself into a hole here, but the client raising the argument involves blackmailing someone somehow. It seems implausible, though. But you wouldn't want to advise a client to do something illegal. As long as you're not doing that, as long as they're just, raise whatever crazy argument you want in your SAG, it seems perfectly fine to me. Jean Marie?
Well, it actually does. Again, I'm speaking outside outside the practice area, but it does seem that as long as it's not based on, a fraudulent or criminal attempt by the client to put that information forward, that if part of the strategy is that the lawyer raises some defenses but can delegate or can, that the client can contribute their own platform as well, that's a competency issue in that the lawyer would be able to recognize that and can communicate that to the client. I also think, however, under Advisor 2.1, the lawyer is obligated by the Rules of Professional Conduct to explain the context of what that would mean if the client chooses to do it, and to help them sort of understand, well, it has these implications, and you certainly can choose to do that if indeed there is a platform for them to do that, but this is what it may actually do to your legal, to your legal proceeding. And I'm telling you this as your lawyer, but ultimately it would be the client's decision.
Yeah, so I guess an example of something, if the client says, I want to use my SAG to threaten the panel, you'd be obligated to advise them not to do that. But short of something really outlandish like that, I think you actually have a duty of competence under the RPC applying to client communication, as Jean Marie said, the 2.1 on your duty as counselor. You have to, if they've got an argument you can't raise, you must tell them about the SAG. If you forget to advise them of that important legal right that they have, that would potentially be a professional misconduct. So definitely steer clients in that direction if they're insisting on arguments that you can't ethically raise. But you have to be careful about drawing that line, because just because an issue is likely to lose doesn't mean you can't ethically raise it. Not by a mile. And
just because my job is partially to just lay a lot of rule numbers out there for you too, the whole idea that if the client is really attempting through you or through the process to do something criminal or fraudulent or threatening, that also becomes a violation of 8.4, which is sort of our generalized misconduct RPC, and that is 8.4A. it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, nor knowingly assist or induce another to do so, or through the acts of another. And that is if it would be a criminal act under B, or engage in conduct involving dishonesty, fraud, deceit, or misrepresentation under C. So I would definitely bear that in mind in that decision-making process.
Okay. Any other questions, comments? Okay, here's one that I think comes up all the time. Your client never responds to your initial letter. Are you obligated to do anything further to attempt to communicate with the client? Does your obligation change if the client had an interpreter at trial, or if they had a foreign name but you don't know whether they didn't use an interpreter at trial? Is that relevant? How about if there's a documented history of mental health problems or intellectual disability? What's your duty to investigate? So there's a lot there. But I think starting with just what if they don't answer you? Is you write them one letter, they don't answer, what now?
Well, so the RPCs that are involved are essentially competency 1.1. What do you need to do to actually accomplish the goals of that representation if the client does not answer one attempt to communicate? I don't set the standard by any means, and I only speak here. I'm not setting, these are not the Bar Association standards. This is just my thoughts as a resource. But one communication not responded to does not seem to be adequate enough if you've got a client where you suspect for many reasons, we're talking about perhaps a need for an interpreter, perhaps a history of mental health problems or intellectual disability is non-responsive to. And I can say that even from having been in private practice for 20 years and working quite a bit with the elderly and disabled, who often had a difficult time with communication. So you've got to do more work. And that goes to 1.3, which is diligence. And actively managing the file and the communication. 1.4 is all about a lawyer has an affirmative obligation to communicate material pieces of information to a client in a way that essentially 1.14 says, in so many words, in a way that works best for that client. So if you have a concern about an interpreter, or if there are other kinds of issues that could arise to make communication difficult for the client, what do you have, or what are the resources that you can use to make some additional attempts to reach out to that client? And with all of those resources and those attempts being unsuccessful, and the client has essentially just disappeared or is refusing to communicate to you, then I think you're looking at possibly a 1.16 issue, and that is an attorney can't really represent a client if the client will not create that attorney-client relationship and should seriously consider withdrawing from the matter. Yeah,
and these different wrinkles I added here, I think, they're intended to get at the idea that a lot of times clients don't talk to you because they're just not interested in being engaged. But it's really hard to know based on a single letter. I've certainly had situations where a lawyer claimed not to have contact with the client, and after having sent a letter, and it turned out the client was illiterate. And trial counsel knew that and could have told appellate counsel that. So I think from where I'm standing, I'm obviously not the ethics person, but for me, a minimum, if you don't hear from the client, is contacting, or at least attempting to contact trial counsel, because they might have information about the client's English proficiency or disability or mental health problems, which may not be evident on the record. It might also be evident on the record. You start, you send the letter, you don't hear back, you start reading, and then you're like, oh, look, an interpreter. I didn't know that apparently they only speak Amharic. Maybe the reason they didn't respond is because I sent them a letter in English. And so that might prompt you to, again, either contact trial counsel and find out, do they speak any English, or just try sending them a letter in the language that they apparently speak.
I'd just like to bring up one more piece here, although there may be some questions and comments from the group. When I was reviewing this, I also came across an older ABA formal opinion. Now, their formal ethics opinions are only advisory to Washington lawyers, although they call them formal opinions. And this one is 07-448. And it's appointed counsel's relationship to a person who declines to be represented. So let's say with your due diligence, you've determined that, it's not an interpreter issue, it's not a mental health issue, it's not an intellectual disability or other issue. They're just basically, what do they say, ghosted? They're just basically left, and they don't want any more involvement with this situation or with you. 07-448 talks about the client-lawyer relationship as a consensual one, and whatever purposes may be served by requiring lawyers to provide services relating to this person, the person refusing representation is not entitled to expect as a lawyer the duties arising out of the client-lawyer relationship. And the lawyer's ethical duties are limited to those obligations a lawyer owes under the rules to tribunals or the rules of professional conduct as they relate to persons other than a client. So I don't know of any Washington advisory opinion that speaks as directly on this piece, but I think this is something that you may want to review if you're a member of the ABA. You can get this at their Center for Professional Responsibility, or perhaps you'll be able to Google this opinion to kind of look at that as another piece of analysis. The opinion goes into much more detail as well.
Okay, and we are falling behind on time, which always happens in ethical.
Because the hypotheticals are so good.
Great. Hypotheticals are fun. It's easy to get into depth. If you have a question, please just type it in the chat, and we'll see if we can circle back to it. But for now, let's forge ahead with hypothetical 5. I think this one's pretty easy. Your client demands weekly updates on the progress of her appeal. You assure the client that there will be nothing to report for months on end because of how slow the appellate process is. The client is unmoved by this argument. What's your obligation?
So I'll throw the rules out. 1.2, scope of representation, particularly comment number 2, which talks to the piece that when a lawyer and client are not in agreement with how the process goes, it does speak to clients normally defer to the special knowledge and skill of their lawyer with regard to how to accomplish their objectives. Lawyers usually defer to the client regarding the questions, the expense to be incurred, or just other directions. And that if it's not working, under 1.4, making sure that there is an affirmative communication to the client that you somehow have in your record, which it sounds like if you're getting weekly updates, hopefully there's notes in the record about the communication. If the client is unmoved in the argument, recognizing 1.14, which is dealing with the client with diminished capacity and trying to weigh that into how you're going to manage that relationship. And there's always 1.16, which is a decision to withdraw if the client is harassing or the behavior is becoming extreme.
Yeah, and that might speak to something like a client who, when you say, no, I can't talk to you every week, I've got lots of other clients, they start retaliating by filling up your voicemail and making it so that your other clients can contact you. That maybe that kind of extreme circumstance might lead to withdrawal.
I also have calls from attorneys where the clients are starting to harass their staff, and that becomes even sort of a higher level of concern for the attorneys.
Right. And so you have, I think, Jean Marie, when you were talking about the diminished capacity, I think the idea there is sort of, okay, maybe you might have to accommodate this client at least somewhat to keep the client. And it's not like they get a different attorney, anything's going to be different. For this client's legal rights to be effectuated, maybe you got to play ball a little bit, as long as maybe, you know, they're not asking for something that's reasonable, but it's also not asking for the moon, sending them a letter every week or talking to them on the phone every week. As long as it's limited amount of time, maybe that would be necessary. But obviously, it's a question of scale. If they're asking for something that's that's totally unreasonable, going to impact your ability to represent your other clients, you don't have to do that, ethically speaking. Okay. Hypothetical 6. I think this one is interesting. A lot of what is interesting about it is the sort of lack of a clear mechanism to follow for issues like this. But you make an inadvertent misstatement of fact at oral argument. You don't realize this until after oral argument when you consult the record. What's your obligation? And what's your obligation if the prosecutor makes a mistake during oral argument in your client's favor? They say something, it's wrong, but it helps you.
So the two RPCs that I have pounded on with this is, let's just start with sort of the broader RPC, and that's 4.1, truthfulness and statements to others. I'm looking particularly at comment number 1. A lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. However, a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. And then it also speaks to misrepresentations can also occur by partially true but misleading statements or omissions. The issue becomes with a misstatement or an omission, it comes to a duty of candor toward the tribunal, where you have made an inadvertent misstatement of fact at oral argument, and that is your obligation to be sure that you are not making a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or of law previously made to the tribunal under 3.3A1. You know, the whole piece of comment number 7 goes into does speak specifically to defense attorneys. The duty stated in paragraph A applies to all lawyers, including defense counsel in criminal cases. And it does speak in some jurisdictions other than Washington. Courts have required counsel, for example, to present an accused. This is where you've got someone actually making a misstatement intentionally. Some courts, and I'm paraphrasing, allow the lawyers to present the accused as a witness or to give a narrative statement. But this comment, which is a Washington revision, which means that Washington specifically has made a change from the ABA model rule, says look at the State versus Berry-Smith case and recognize that, and I did just look at that case before our webcast here, that lawyers can't really allow anyone to testify falsely. Again, I'm sort of generalizing what the takeaway is from that case. But I think under 4.1 and 3.3, the lawyers should be extremely careful about allowing inadvertent misstatements of fact or oral argument, A, by themselves, or B, if someone else, if a prosecutor has made it, then some of that may have to do even with trial tactics as well. Great. By the defense counsel.
Right. Sorry, we don't have that comment up here. It's hard to fit some of these RPCs on a PowerPoint.
There's a lot of RPCs, and there's never one that stands alone. So yeah.
But just remember, this will be recorded. So if you want to revisit anything for your edification, you'll be able to do that. So, and just to be clear, the prosecutor makes a misstatement of fact that's favorable to your client. You do have to correct that. And And I think there is there's an interesting question there. How do you do it? There's no rap about how do you correct I think I see Kevin just asked that question in the chat. As a practical matter, how do we correct a factual statement made at oral argument after the fact? What can we file? That's one reason why I think that's an interesting question, because there isn't an established procedure at the Court of Appeals. And maybe someone has had this situation occur. Maybe you can raise your hand or type in the chat if you've ever had this happen. Certainly, I know at the U.S. Supreme Court, there's a practice of writing letters to either correct something that was said at oral argument or to elucidate a point. Sometimes attorneys at the SCOTUS get kind of the justices will ask them some kind of question, and they'll say, geez, can I respond to that? Can I respond to that later? I'm not sure what the answer to that is. And so there is that practice of sending letters to the court, which I assume are served on all parties. And I think that's essentially what you have to do, is you write a letter to the court, serve it on the other parties. I'm not sure, file it. I'd file a declaration. Thank you, Jill. I think a declaration would be appropriate, but it's totally free form. Whatever you can think of as a mechanism, as long as it is transparent, as long as it's part of the record, it's accessible to all parties, I think is fine.
So I think that from an RPC perspective, I think the key is really not ignoring it or adopting it. So whatever the mechanism is that works best on the appellate level, you can't just let it go in that respect. That's what the RPCs say. That's also, in addition to 3.3, it's all about 8.4 too.
Yeah, so we're a little bit in the playing jazz kind of territory when it comes to the mechanism, but the ethical duty is clear. You got to deal with it. Here's another interesting one. This one actually does come up once in a while. An inaccuracy in the transcript. You have a client who was arrested and read her Miranda rights, and she told the police, "I want to talk to you." But the transcriptionist heard it as, "I don't want to talk to you," and that's what they wrote in the transcript. You have, maybe for some reason that this is a mistake, and you review the hearing audio to confirm it, and yes, the transcriptionist was wrong. The client said, "I want to talk to you." I think this is probably a similar situation to Hypothetical 6, but what's your obligation? And is there a difference, what's your obligation to investigate if you don't, let's say part A of this hypothetical is, there's a mistake. Part B of this hypothetical is, well, what if you just think there might be a mistake? Do you have to investigate?
So I think you do. Under RPC 5.3, that sets out the premise that if there's anyone else handling that case, including the transcriptionist, that is essentially contributing to your representation on that case, you have to make sure as a lawyer that they're in compliance with the rules of professional conduct. So whatever RPCs are your standards, they have to be applied to a transcriptionist. And then we go back to our 3.3, duty of candor to the tribunal, 4.1, and 4.4. And just to kind of underscore that, for RPC 3.3, duty of candor to the tribunal, I would look at it, again, another Washington revision, comment number 8. It talks about offering false evidence, and it's for the lawyers that aren't sure where it is. The prohibition, in terms of sort of the gray area, is it false or isn't it false? The prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. The lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that the evidence is false, however, can be inferred from the circumstances. Thus, although lawyers should resolve doubts about the veracity of testimony or other evidence in favor of the client, the lawyer cannot ignore an obvious falsehoods. And so I would opine that if the lawyer is in doubt, the lawyer actually has a duty of 1.1 and 1.3, diligence and competency, to check into that to make sure that it is accurate. Because does the lawyer really want to get into an argument or have to explain themselves as saying, well, I wasn't sure if the veracity of the testimony or the transcriptions was correct, and I only knew this much, but I only knew 20%. I didn't know 80% of the information that I needed. I'm not sure how convincing that would be.
Okay. And you know, when I said this one comes up a fair amount, it's probably not as stark as this, where it's something just unambiguously helpful to the client. I think much more often you have mistakes in a transcript which are irksome. They muddy the record without being clearly favorable to one side or the other, in which case you have more just diligence and competence at play of, you know, is this so bad it needs to be addressed? And then you've got, of course, the often incredible headache of trying to get the court reporter or transcriptionist to do what you asked them to do. But that's a topic for another lecture. That could probably, you know, wrangling the record could probably be its own topic. So we're just about out of time here. I think the remaining hypotheticals, put them towards the back because they're sort of the less interesting ones and kind of tend to be more tactical issues. I think they have pretty black letter answers too. You know, so number 8 is essentially, you know, your client did a bunch of heinous stuff, 14 counts, it's really nasty. Can you just summarize it, gloss over it? As long as you're not being dishonest, I think you can, right?
Unless it's a material misstatement of fact, and
right.
Whether or not that's really critical to if that's critical to the appeal. So,
right. Yeah. So, and then you have got, of course, a tactical question. How much should you summarize? You know, where does it look like? Where do you draw the line that it looks like you're hiding something? But as long as you're not making a misstatement, ethically, no big deal.
There is a comment about the transcriptionist.
Yeah. Mary Kay High is asking, there are courts transcriptionists. If you point out in the brief the error and don't argue.
I would agree with your summary, just in terms of pointing it out, not arguing the false information, but arguing whatever information is truthful.
Right. Call attention to it, but yeah, do you have to go through the headache of getting the transcript changed? As long as you can call the court's attention to it, probably not. Yeah, that's a good point. Number 9, the prosecutor makes a mistake on the cost bill. Says the transcript only cost $500. You know that it probably cost more like $5,000. Can you ignore that? I think we're pretty much out of time. Do we have a kind of a yes or no answer here?
I hope we've led everybody to we can't ignore it. Duty of candor, duty to make sure that you're not, presenting false, misleading, erroneous information.
Or failing to correct.
Right.
Misleading information, which really stings if you're trying to get your client to pay $5,000. But hopefully OPD doesn't ever make that kind of mistake. It's very rare. Our staff, and heck, cost bills are almost not even a thing anymore, fortunately due to changes in the law. So that's hopefully no one will be faced with that unpleasant situation. Number 10, you've got a dependency case in the department. The department had reasons for removing the child and filing the dependency in the first place, but the legal issue in the dependency isn't why did they file it, but rather, is the child dependent at the time of the dependency trial? So do you have to put the basis in there? I'd hazard, of course, no. It's actually doesn't really control the outcome of the trial. Should you omit it? Probably not. It looks like you're hiding it. And of course, I think this has the same answers as the ones the last few of, you can't have a material misstatement. You can't mislead anybody. But as long as you're not being misleading, you're not really being unethical.
From a trial point of view, and that's my experience, it was never let anyone else say what you could have said first and said it better.
Yeah.
So,
but that's tactics. And so, you're trying to tell your client's story in a way that doesn't make them look like a monster. That's threading a difficult needle. But that's,
that's competency 1.1.
Yeah. Number 11, you have a stolen property case. Your client's defense was the lack of knowledge that the property was stolen. And the best piece of evidence is that the police found the label identifying the property's owner in the client's trash. Do you have to include this in the statement of facts of your brief? The prosecutor knows it. The prosecutor's going to bring it up. I think it's probably dumb not to include it just because you look dishonest. But are you being unethical if you simply... And then, of course, if the prosecutor completely fails to mention it, now you've got in their brief, now you've got a more difficult question. But if you're talking about, and if you're talking about, how complete does your brief have to be in terms of the fact? Do you have to include every bad piece of evidence against your client? Probably not, but then again, you probably should. As Jean-Marie said, you might be considered incompetent if you let the prosecutor bring that piece of evidence on the court and make you look like a big liar. It's probably not a competent way to go about representation. Not that interesting of a hypothetical, honestly. That's why it's almost at the end. Number 12, your client was rude and disruptive at trial. You don't need to put that in your brief. It's not relevant to the issues. You probably shouldn't put it in the brief. What's more interesting to me is, what if the prosecutor puts it in the brief? What should you do? I would posit you should file a motion to strike and say that the prosecutor included. Here's the ethical rules. The prosecutor is putting in this highly prejudicial information that's not relevant. I don't know if that's ever come up with anyone of having a prosecutor put such, have such kind of ridiculous, unnecessary, and prejudicial information in their brief that it's to the point that it looks like they're trying to get to try and unduly influence the judges against your client. Could you move to strike that kind of stuff? Would you be brave enough, or would you just let it stand on its own? Probably isn't a clear answer there. And Jean-Marie, what do you think?
So I can't opine on sort of the tactical aspect, but I can state that if you believe that the prosecutor has actually violated a rule or rules of professional conduct, can you or must you report that to the Bar Association? And that RPC is 8.3, reporting professional misconduct. And our rule is different than the model rule, and that is our lawyers are not required to report another legal professional's violation of the rules of professional conduct. And that's actually to sort of allow for sort of a more open grievance process. There are some jurisdictions, many of them, in fact, most of them, where if a lawyer is required to report it, and then the pushback is that then if it's basically not founded on anything substantive, then that lawyer then can be found, who reported it, can be found in violation of the RPC. So that is not present in Washington. And if there is information reported to the bar, it is protected by 1.6. So a lawyer should get their client's informed consent before they're giving this information in any kind of filing of a grievance.
Okay, and that's essentially all the time we have. Thank you so much for coming. Everyone, please hang around a second for some instructions. I'm going to stop the recording.